Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. I'm looking at a book this morning which we have reviewed before. This is a book from Jordan's Publishing Limited in Bristol, and it's called Taking Security. It's now in its third edition and it's been written by Richard Cainan. Now this is the book here. It's actually Richard Calnan, I must get his name right. There's the front of the book and there's the back, and you can see there's a quoted review from us of the previous edition. The book itself is interesting. I'll explain what taking security means for people who don't know later. This is the index at the back, and then you've got a standard structure. For instance, this is on set off, you can see that there. You've got a standard structure where you've got the paragraph numbering at the sides to find things. You've also got, as you can see there, footnotes which have mainly the case law details, that sort of stuff, statute law and so on, and the more nitty-gritty sort of information that you need for it. That's actually the front cover. As you see, Mr. Calnan is a solicitor, Norton Rose, and he's a visiting professor at University College London. That's the preface to the first edition, and then there's another preface to the second edition there, and then there's the new preface to the third edition dated the August 2013. So it's some time ago. These are the contents section there, and you can see the huge amount of contents that's in it. So I just go through various chapters there, and then we get towards the end. You can see there how it's structured. Chapter 9 up to chapter 12, which I just showed you, set off. Then you've got cross-border insolvency, which is useful again. And then you've got at the end the table of cases and statutes, of course. And then what you do is you start off here with the main introduction, and it starts off how the book's structured. It's worth reading that just to begin with. It is an e-book, which you can see there, so do have a look at the Jordan's website and you'll get some information about this subject. The review we've written is on the web and in the journals, and what we say is this: we've given it a title, For Practitioners, an essential and practical guide to securing payment on a sum of money, which is effectively what taking security is all about. Does someone owe you money? Don't worry, or rather don't worry unduly. This book, now in its third edition from Jordan's, will show you and your clients, if you're a practitioner, how security is taken and enforced under English law. And obviously mainly it's about property, but there are other ways of doing it. But security therefore is defined as follows: as the creation and enforcement of proprietary rights to secure the payment of a monetary liability, somewhat in the nature effectively of a secured loan, if you like. It's not quite the same, but we're trying to give some comparison so that if you don't know what taking security means, you can get some concept immediately of what we're actually talking about. Therefore, the book's primarily concerned with two issues, really: property law and insolvency law. And it's worth noting that the author, Richard Calnan, explains that the new edition of this highly regarded title has been prompted by the recent changes to the system for the registration of charges created by companies and LLPs. I think that's quite important to bear in mind, because obviously the charge on a property is basically the only way you're actually going to get your money, if you ever get it back, because obviously once the charge is on, until that charge is actually met, they can't sell the property. So you can see that there's you've got a real hold over the person. Obviously if the property is sold by way of a trust for sale or something, you might have a difficulty then, because again you may be in a list of people who are all owed money. But at the end of the day, you should be able to get your money back. That's the theory anyway. Obviously in practice there can be difficulties. Mr. Calnan goes on to say the new law is more logical and simpler than the older law, and as a result the practice of registering charges, this is on the land, has changed, which is why chapter 6 of the work, which deals with all aspects of the registration process, has been substantially rewritten. Also, further changes have been covered in other chapters, including chapter 7, which looks at priorities, which I've indicated to you, because there will be a list of priorities in how much is being owed by the debtor to the various creditors, because in these circumstances sometimes you may not get your money, of course. So for busy practitioners, the book is impressively easy to use. We like it immensely. It's an easy navigable book. It's divided over 14 chapters into 7 sections from A to G, which together cover every conceivable aspect of this taking security for the money that's owed to you. Part A, for example, enumerates and explains the various types of security that are available, for those who may be wondering. And international lawyers, particularly in today's global market and economy, will be especially interested in Part G, which I alluded to earlier, which covers both cross-border security and cross-border insolvency matters, which again is important because of the nature of how the planet is changing with the way we do our business. It's no longer compartmentalized into nation states, as it were. It's much more global. Whatever issue you wish to look up then in this volume, which is about 600 pages long, the minutely detailed table of contents, which is, as I said, I showed earlier, is actually quite substantial, and the numbered paragraphs will certainly help with navigation, as well as the extensive index at the back. The expected research resources which are here include tables of cases, statutes and statutory instruments, and there's a wealth of additional references in the meticulous footnoting throughout. That's where you'll get the case law details, basically. Let me conclude by saying, as has been said of the previous edition, this reliable and detailed text is a real time saver and an excellent guide to a complex area of law. If you're advising clients, therefore, involved in any way with secured transactions, you'll need this book as an essential reference. The publication date is actually cited at December 2013, although the preface is, for the 3rd edition, is earlier. And I'm recording this in the summer of 2014. Just to remind you of the book again, 600 pages, quite heavy. It's a hardback. The back again. And then just opening it in the middle anyway, enforcement. Here we go, an important area. You see, it's covered by a very large range: the creation, the registration, enforcement, effects of insolvency, liens, guarantees and indemnities, and so on. I must say that to some people, and when I first started, I found some of this stuff to be really difficult to follow, and I think what Calnan has done is made it much more simple. So can I thank everybody concerned for producing it from Jordan's, and obviously Mr. Calnan himself, and also do have a look, as I say, at the web and the journals for our review. Thank you very much. Bye-bye.